for Success Express, your business, career, and financial radio magazine. Hosted by Lisa and Nancy, editors of BigBlendMagazine.com.
I feel like it's the Big Blend party train. We're taking the 310 to San Diego.
No, it's supposed to go to Yuba.
No, we're going to San Diego because it's sunny and beautiful. We're going to go hang out with San Diego employment attorney Ward-Heinrichs. He's back on Big Blend Radio Success Express show today to talk about the commish.
The what?
The commish.
The commission?
Yeah, California Labor Commissioner cases. So what's happening with that? And it's got to do with, wages and hours and all that good stuff. So he's going to explain all that. And I never even thought about the role of a commissioner. Like, it's just, it almost sounds British to me for some reason.
Are they lawyers?
He's going to explain it. He's
judges?
He explains all this by the, I'm always glad when he's on the show because I can understand things. Before he comes on, I go, okay, I don't know what all these legalese things are, but he undoes the legalese and makes it, into English. So we're always excited to have him on. He is one of our regular guest contributors and experts. And if you go to blendradioandtv.com, you'll see him in our expert department. And you can click on him, and you'll find all kinds of good advice, a lot of interviews and articles to read. And also, we also feature his articles and interviews in our Parks and Travel magazine because he works as well. Being in employment law, you also deal a lot with the hospitality and tourism industry, especially being out in beautiful San Diego. But most importantly, go to his website. He's also got a great blog there. It is bestemploymentattorneysandiego.com. He's also on Twitter at Ward-Heinrichs, and you'll find him on Facebook, too, always posting some what's going on. And there seems to be a lot going on in the world of scandals and employment law. But, Ward, welcome back. How are you?
I'm doing well. How are you guys doing?
We're doing good. We're doing good. So, do you like our party train? Do you think it's a pretty train?
Well, yeah. I love the intro with the whistle and the bell dinging. Yes, I think it's an amazing thing.
Johnny Cash was going to just jump on the train, and hang out with us for this. The Man in Black meets the commish. Okay, so the commish, that's. As soon as you said you wanted to talk about California Labor Commissioner cases, I'm like, it's the commish. And I'm like, I don't even really know what a commissioner is. Sorry, but I don't. And so unlegalize it.
Well, yeah, it's an appointed position that's within the Department of Labor Workforce Development. So it's one division, and it's really called the Division of Labor Standards Enforcement, and the labor commissioner is in charge of that. And so they enforce many of the rules that apply to employees and employers, and not everything, but a lot of it. The wages, for sure. Some of the retaliation laws they enforce as well. And if an employer doesn't have enough workers' compensation or doesn't have workers' compensation insurance, they file citations for that as well.
Wow. So is this an elected position, or are the people who work there lawyers, or what kind?
Yeah.
How's that work?
No, it's not elected. I think the governor appoints the labor commissioner, but don't quote me on that. I'm not absolutely positive. And lawyers do work inside the Division of Labor Standards Enforcement, but most of the employees that work there are not lawyers. Most of them, they have all sorts of different – it's a big organization. So they have many people doing many different jobs. They are located throughout California. We have a commissioner's office or a labor commissioner's office in San Diego. And we might even have more than one. I've only been to the one that's close to downtown in Mission Valley. And most large cities have them too. They're all over the place.
And so they help you also get licenses, right, that you may need. Like in your article, and everyone, Ward's article on this is up on blendradioandtv.com, and you talk about it. They help employment-related certificates and licenses in agriculture, entertainment, garment, and car wash.
That's weird.
That's like
car
what?
Wash.
I know, at the car wash. So, where did that come from? That's their thing. That's we're going to be part of that. And maybe it's environmental, or I don't know. But that's interesting that they decided that's what they're going to focus on. You know?
Yeah, I'm not sure why they limited it to those types of industries, but those industries depending on what you do, they do require certificates and licenses to do certain types of work, and so yeah, they help with that.
That's interesting. Well, entertainment, it's all the casinos, you know. Just thinking, but I don't know. My mind keeps going. Yeah, the commish. But so this is interesting. So they're not quite lawyers. They're not necessarily judges, but they do have the big purple stamp that can fine you.
Ooh.
They can go boom.
Well, now hold on a second. There are lawyers that work for them, and I've interacted with those lawyers sometimes. If you take a case on appeal, like a wage case on appeal to the Superior Court, which you're allowed to do, and the employee. Now, if I'm representing the employer in that case, let's say that's what's going on, and then the employee may not be able to retain an attorney, so the labor commissioner may assign an attorney to that if they meet the certain criteria. But if they meet it, then a lawyer from the labor commissioner office will represent someone in Superior Court. And their lawyers do other things too. Sometimes they do citation appeals and things like that as well.
So and they get to have a conference too. So this is a little different than going to court, right? Even though it could go up to that level, but it's a little different. And I mean, even Nancy and I were talking about your article, like, hey, people get split up and put in different rooms.
I know.
It sounds like we're going through a border check.
Well, that's the mediation process. Yes, if an employee has a wage claim and they file it with the labor commissioner or the Division of Labor Standards Enforcement, they're the same office, then the employer gets a notice that there's a wage claim, and part of that notice also gives them notice of a conference, and that conference really, in my experience, almost always is a mediation. That's the focus, to see if the parties can settle. And that's where where two people, both parties go into different rooms, and the labor commissioner will go back and forth. And when I'm involved, I insist on that, and I think most of them want to do that anyway. It's just a better way to mediate a case. One person in one room, one in the other. You have your little powwows. You talk to the deputy labor commissioner who discusses that with you, and then they bring your offer or demand to the other side, and then they talk about it. So they really do try to settle cases, and they're pretty effective at it.
Wow, this is neat.
But is that now before, or like you can or cannot have a lawyer present?
Yes, you can have a lawyer present. For both the employee and the employer can have an attorney present. There are some issues with an employee actually having an attorney there. I mean, they're allowed to, but they might have to come out of pocket. I've heard of ways that you might be able to do it on a contingent basis, but it's kind of tricky to get a portion of the award. So there are some. So I guess really what I'm saying is usually employees don't have attorneys, and not all employers retain attorneys. But an employer is more likely to have an attorney at a labor commissioner hearing than, or at a conference or hearing, than the employee.
Doesn't it save everyone money when you go to these kinds of like mediation conference kind of things versus, okay, everybody, let's just go to court. Like, that's it. We're suing you, to have these kind of steps beforehand. Doesn't it save people time and money in a way to do this and give maybe an employee that isn't getting paid or some kind of way to do this versus sometimes, I don't know. I'm just saying it seems that this gives a little structure for those who need it.
Yeah, it's a pretty effective office, I think, and it's a good alternative to going to court for an employee. There are no costs associated with it. The employee would have to represent themselves at the conference unless they retain an attorney. At the hearing, though, the deputy labor commissioner who was trying to mediate and settle the case represents the employee before the judge. Now, you also said that there are no judges. Well, there are. They're called administrative law judges, so they're not the same as a superior court judge, but they fill a function that's very similar. although in a less formal situation.
Okay, so now for you, like, what are you finding yourself as an employment attorney being part of this? Are you seeing a lot of specific kinds of cases? Is it mostly like wages, that kind of thing that you're going in, and is it, are you, if so, is it more on the employer or on the employee side?
Yeah, it's really built, the way that system's built is for the employee to represent themselves with the help of a deputy labor commissioner if it goes to a hearing. So again, normally the employer, it depends on the case and how deep the pockets of the employer are, but the employer will obtain an attorney, and the employee is relying on the labor commissioner to help them out.
Like a public defender almost.
Yeah, pretty close, very similar in many ways.
Yeah.
Now, you were talking about, the cost and things like that. Yeah, it's a cheap way to go. But remember, if an employee elects to go to court, the code generally allows for the employee to recover attorney's fees if they file in court. So there is protection for the employee there. As a practical matter, though, many of these cases just settle. So often, if I represent an employee, it's a demand letter process, and the employer goes, oh, boy, I got a problem here, and you settle it versus even filing in court or going to the labor commissioner. And quite frankly, that's the quickest way to do it. But this is another pretty quick alternative that doesn't have the formalities of court.
Is there any limit to the financial side, the money side, if you're making a claim? If it's like a whole lot of money, you got to go some other route instead of this?
No, there's no limit on the amount.
Okay.
But I mean, typically it's set up for people who have smaller claims. Not huge wage and hour class actions, for instance. It's really not set up to do a class action. I don't even think they can do them. Yeah, because it's wage versus
salary too. Yeah, if it's wage versus salary, it's a different. So, do salaries get involved with this or no? Like, if it's
they can. Yeah.
Okay.
They can. Yeah.
Okay.
It's possible.
So, what kind of businesses do you see get involved in this? Is it every kind of business? I mean, I know they say car wash, but you've got entertainment, so hospitality's got to be in there. I mean, agriculture. So is it this is it really mostly the money side when it comes down to these kinds of cases?
When you say money side, I'm sorry.
I mean, like wages and salaries, that kind of thing, in time. Did you talk in on time or?
Yeah, most of the cases I do that have the labor commissioner involved are wage cases. The other one I see fairly frequently is workers' compensation cases. And, I mentioned that in the article. Those can have very hefty fines that go along with them. Now, that's usually not that's where the labor commissioner files a citation against the employer for not having workers' compensation. So they'll say, hey, you violated the law requires these penalties, and we want to get them from you. So there's a whole notice procedure, very similar to the wage and hour type of case, but you do get in front of an ALJ, administrative law judge, and you have a hearing to determine what's the fair result in this case.
Go ahead, Nancy.
I was just wondering now, because now I'm thinking about car wash. So
my car does need to be washed. We keep going on dirt roads and hanging out with snakes and stuff.
So let's say an employee at a car wash slips and falls because it's all soapy and wet, and so he goes to his boss and he needs medical care, and the boss says, sorry, don't have any, or no workman's comp, so too bad for you, and besides that, you're fired.
Yeah.
Wow.
Yeah.
Nice.
Well,
here comes the Nancy setup.
Yeah, I know. So then the guy could go and then go to the commissioner and say, hey, I fell because it was soapy, and then I got fired because I said something. So so he doesn't really need an attorney, But would it cover like if the man is found, oh, you don't have workman's comp, so you're going to get fined? Does that mean the guy would automatically win his case because the guy didn't have workman's comp, or would it be two separate things?
Well, you brought up a bunch of things.
Yeah, I know.
There are two different work comp processes. One is they say, we found out that you don't have workers' comp insurance or you don't have enough. I mean, sometimes it doesn't cover enough employees. So we're going to file a citation and get penalties. The state collects those penalties. The other one they do handle is a case that would be filed by an employee for failure to have workers' compensation. And that is brought by the employee to get coverage for their injury. And then there are penalties associated with that as well. And both can be very expensive and messy. Now, the third thing you brought up, though, was, well, he got terminated, and it sounds like a wrongful discharge. Now, that the labor commissioner doesn't take care of. They might take care of a retaliation, but normally that wouldn't be retaliation is different than wrongful discharge. Sometimes they can overlap, but not really quite the same. So a wrongful discharge would be filed in Superior Court, or what you have to, depends on the type of wrongful discharge. Keep it simple. That has to still be filed in Superior Court, and so it would be a separate case.
Okay. Now, does that happen where all of a sudden here comes this, claim, or this is the issue with, employee, just like what Nancy's, big setup is here. You end up having to do like 3 or 4 different things as an attorney, going, okay, you're going here, 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 here. I mean, because it's multiple things. Do you find that kind of thing happens, like multiple, like crazy episodes?
Well, where I have seen it is where an employer fails to have workers' compensation. And quite frankly, I've done pretty well in those cases where I say, well, there are different ways of calculating the damages. And, so, very often you can't disprove it, but you can reduce the amount that's owed. So you go, you're not really calculating it quite right, and you point out the code section, and you talk about cases, and you say, and then you go to maybe you can settle it, maybe not. Then you go in front of the ALJ and say, here's our case. We don't think they're really calculating it correctly, and I've been able to reduce them dramatically in some cases. In other cases, maybe like half, but still half's way better than, 80,000. 40,000 is much better. 40,000 is still a chunk, but, and then often you can get a payment plan and things like that anyway. So,
oh, wow.
Yeah. So there's,
layaway.
You know what?
Employee layaway.
I know. The workman's comp layaway, fine layaway, sorry. It's the Walmart. But okay, so that's interesting. So that they even have that. So, but your article said that they could also. This could be really serious. There's payment plans if you're on the winning side, like you're doing, right? Because everybody ward is aggressive. It's like, you're going to go sell it. You're going to go, hey, this is not that bad, but it can be bad. Like you said in there that an employer can actually look at going to jail over something like this.
Yeah, and that was the other thing I was getting to was I have seen them where the labor commissioner gets some type of fine, and then for whatever reason they're offended by the case. So then they may tip off the district attorney, or the district attorney may find out independently. It kind of depends. But usually, from what I've seen, it comes from the labor commissioner, and they're saying, hey, I think we got a problem here. Maybe you should consider filing this as a criminal case. So I have represented I used to do criminal law a lot back when I first started practicing law. So I'm very comfortable in criminal court still. And I sometimes still on a work comp case, if it's filed as a criminal case, will go to court for a client who has that work comp problem. And then, you start negotiating and doing whatever you need to do to do the best you can for your client. Yeah. I mean, I haven't had someone go to jail on that. It really has to be bad. It probably has to be more than one offense. Like if it's 2 or 3 times, well, maybe you're going to go to jail. I think the first time around, very hard pressed to put someone in jail for that.
It's interesting because, of course, I'm thinking back to South Africa, and I knew a person who just, if an employee opened their mouth, they just all fire them, and and it didn't matter what it was, and the person was just always firing somebody, and nothing ever happened. Of course, that's South Africa, and I was just thinking if that person had a company in any parts of this country would probably be in jail. Because, I mean, it was just, if somebody came in and they had a complaint or they're sick or whatever, it's like, I'll fire them. You're fired. And so it was really funny because every Friday we'd get together and it'd be like, so how many people did you fire? I'm like, none. Try not to, trying to keep my people because I bothered to train them.
Wow, this sounds like the sign of the times.
I know, but it was like, I'll just fire them.
Everybody gets fired around here these days. Nancy's going to fire me soon. But that's interesting.
Well,
yeah, but it was just like, it was it's easier to fire them. And I was thinking, well, maybe that's, because it was South Africa and they had different laws, I guess. But
yeah.
I mean, the way you've described it sounds more employer-friendly than most of the United States. But I will say we have the at-will doctrine in California, and there are other states that follow it too. And that means that you can leave anytime you want, and they can fire you anytime they want for no reason at all. So they just go, hey, goodbye. Now, where you get around that is if you suspect that they are firing the employee for a reason that's against public policy. Discrimination's a star example of that. If they say, hey, I don't like you because you're a woman, and I'm firing you, well, that's a wrongful discharge and discrimination.
Right.
But there are many different instances of that. A pay issue may come up, and the employee comes in and says, hey, you owe me overtime. I worked 12 hours this day, and you only paid me for 8. Well, if the employer turns around and says, well, I'm not paying you and you're terminated, well, that's a wrongful discharge too. So that's their the at-will doctrine isn't absolute. There are certainly statutory exceptions, but it's pretty powerful. I mean, employers in California really have a tremendous ability to fire employees without cost.
Now, what about when you talk about overtime and things like that, and I just back in the day, remember that being you had to really watch your paycheck that they didn't screw you on that.
Oh yeah.
And I always think the overtime that was something that it was. Do you see that being part of the issue, like that you see going into these cases with the commish? Do you see that a lot, the overtime issue of not getting your overtime?
Yeah.
Yeah, overtime's a common claim. Meal period's a pretty common claim. Maybe not getting paid at all for certain time or minimum wage violations. Those are all pretty commonly filed with the labor commissioner.
Okay, and so everyone, see, if you read Ward's articles, he gives you a heads up on these minimum wage changes and all these changes that you need to know. I want to go back to the workman's comp part. I know this is in Florida, but my ex at that point, he was in roofing. I know for some reason on these segments we get into all my past history, but no. Anyway, he's
very interesting.
No, he worked in this this roofing company or whatever, and he had a friend that was going through hard times, and so they would have day laborers there that would come in and and this guy, now I don't know what happened, but this guy came to the door. And he was a friend of ours, and he was just working in Ray's company at that time, just as a day laborer, nothing permanent. And he had like an axe go through his hand, and I had to rush him to the ER.
Ooh,
and I mean, it was bad. And I'm like, well, what about insurance? And he didn't have, I think he was getting divorced or I don't know, some drama thing was going on. But I was like, dude, you can't have that. You need to go get help. And he was like, and he didn't do it for like a long time. And he just came over to the house, and I'm like, dude, you got to go. And he didn't, like, he was talking about workman's comp, but then they were like, you don't have workman's comp. And so when you're in that kind of temporary thing, isn't that more of a contractor? So you're like, you're on your own.
Because he was a day laborer?
Yeah. Isn't that more like an independent contractor then?
Yeah, pretty tough to have a day laborer be an independent contractor. The more basic the work is, the more likely you're an employee. We've talked about all the different factors that can be used to determine if someone's an employee or an independent contractor. So, and the presumption is everyone who works for someone else is an employee, and then the employer has to prove that they're not if it becomes an issue. So that's pretty dangerous. I mean, it's possible, but it's pretty dangerous to say, well, I'm guy on for a day or two to do a job, and and I'm in the business of construction, and this guy is working on the construction site. It's pretty tough to say that person's not an employee.
Oh, okay.
So in that situation,
I never thought about day labor. Yeah, what happens with workman's comp? I know we've always talked about different things happening and whatever, but I never looked at it from the workman's comp thing because I remember there was a big hassle with it. There was like a mess, and I didn't understand all that. Well,
let's assume that the employee or the worker filed a work comp claim, and the employer says, no, that's an independent contractor. Well, you might have to fight about that and make a determination. But in California, that's a pretty big issue. I mean, you see that like in agriculture and other places where people. Yeah. And we always talk about, well, go to Home Depot and pick up someone to work for you for the day. That carries risk in terms of whether they're really an independent contractor or an employee. So if they make a claim, then the state fund decides, hey, they really should be picked up and covered as a work-related injury, then there is a separate fund that is used to cover people who don't have formal coverage. Wow. But then the employer, presuming that they have now been determined to be an employer, it can face all sorts of bad problems. We've already talked about some of them. And they can get sued for it because the work comp takes work injuries outside of the civil justice system. But if you're supposed to have work comp and you don't, that case can end up as a lawsuit. So there's all sorts of ramifications that can happen that are not good for the person who hired the worker.
Wow. So now what about like the part-time employees? Are they going to get the same kind of deal that a full-time employee would get? I mean,
in regards to workman's comp
to workman's comp and such, because it just seems to me there seems to be a trend in this country that we will hire people part-time so we don't have to give away
health
as
insurance
many
and stuff.
health insurance or as many benefits. So we're going to have 5 part-time employees instead of 2 full-time ones.
Yeah, and that can certainly work for coverage under, what we used to call Obamacare. You have to work a certain number of hours
now
before
we call
you
it no
must
care
do
at
it.
all.
No care.
Yeah, I don't even know what it is anymore. It's been watered down.
I don't know at all.
Whatever.
There isn't even a name for it now.
It's just like you're on your own.
You're on your own care.
Welcome to being self-employed.
But work comp, now, I'm not a work comp attorney, so I'm not an expert in that area.
Yeah.
But I am pretty sure that any employee must be covered under work comp. So if you only work 20 hours a week, you still have to be covered. I think if you only work a few hours a week, you still have to be covered.
Wow. Okay.
Under workman's comp, but then not
under
necessarily getting, you don't get paid leave or health care or anything.
See, this
like
is
that.
all I'm saying is anybody opening a business, go see Ward first.
Yeah, because it's complicated.
Go say, this is what I want to do.
Yep.
I mean, isn't that true when someone wants to open a business or expand or even just right now in business? Go check that everything, you're dotting your I's and crossing your T's.
Yeah, if you're going to have employees, you should always have an attorney and you should always have an accountant.
Yes.
When you start.
And they should be friends.
Yeah. No, it's a good thing. Now, I mean, as a practical problem, businesses that are starting out in the garage who may have a few people working for them in their garage, do they really have enough money? And I get that. I get that pressure.
Yeah.
But I also see the downside of that where, you're small and you really don't have very many employees and you're calling them independent contractors, et cetera, but now this employee's mad at you and they filed a case in Superior Court for wrongful discharge and they filed a wage claim and they need work comp, and all of a sudden you've got this huge mushroom of a problem. And that's, I get the other side. You don't have a lot of cash, but if there's a way of taking care of it. Now, some people, go online and find forms and stuff, but I've seen a lot of problems with those too. So,
I was going to say,
if you can bite the bullet, you're better off having it done right.
Yeah, because this is a deal. Running a business is, there's all kinds of things that come with it, and you have to be prepared, and it's part of your due diligence. And if you can't afford to do it and you can't get a loan somewhere or whatever, you really got to think about it, because it can sink you making big mistakes.
Yeah.
What I love about this conversation is that there's some procedures in there where everybody doesn't go to hell in the handbasket at once. You can solve things step by step. And, you were talking about doing a demand letter. So now I'm saying, can I call you? And we were just laughing about this. I said, I want to call Ward and say, can I send you a list of demand letters? They've got nothing to do with employment law. I just want your stamp. I want something. So the demand letters, does it help? At that point, can things be done, in that way most of the time, where it can be done in this, mediation room kind of deal, and before everything becomes that big atomic bomb. So a lot of these situations on wages and all of that. Do the letters? That's got to be fun to write them. Like
I've been on both sides of that. Yeah, no, I totally hear what you're saying, and I've been on both sides where a client of mine has gotten a demand letter, and so I entered into negotiations to basically get them out with the lowest amount possible. And often I'll say, hey, look, you've got risk here, and here's where this is the dollar amount of risk I see for you. So, it's usually arranged, because I don't think they can prove everything, but maybe they can prove this, maybe not, la-di-da-di-da. So you give them an assessment of the risk, and then you try to do your best to get under that for your client. But now, believe me, no one's happy because they're still writing a check, and not in all cases. Some cases it's frivolous, and you just write a nasty letter back and go, hey, look, this is just junk. So if you want to file your thing, go file it. But then we're going to ask for fees and costs and everything else, and we're going to make your life miserable. So it depends.
This is fun.
Now, but I've been on the other side where I'm writing a letter and saying, hey, employer, you screwed up. And here's why we think you screwed up, and let's take care of this now. And I have to say, in my experience, the easiest type of case to handle that way without filing anything is a wage case where you've got some traction. These discrimination cases generally are harder to settle that way. There's usually more gray area. Usually more facts need to be brought out. So it's not impossible, but it's harder to. So so your bottom line, and I think on your question is, that is a good way to handle those types of cases. Do the demand letter thing. Don't spend, limit the amount of money you spend on an attorney. Don't wait till it's filed. Then you're going to spend a lot of money there, or you're going to get killed. So take care of it up front. And the labor commissioner, they're a pretty good office for that too, because they do have that mediation process. Now, you don't have to enter into it, but if you're thinking, I got some risk here, take a stab at it. See if you can settle it, and you're not going to love cutting the check, but, you probably have some exposure, and it's a good time to get rid of it.
Do they keep track of an employer that maybe has 2 or 3 cases a year? They start looking at them going, hey,
but Dad,
what's up with this?
That can happen. And then sometimes, there's different ways for that process to start. One is what you said. Maybe there's too many cases filed against that, and they go out and do an investigation. And sometimes the DA goes out with them. Sometimes the EDD goes out. So it could be a multiple agency investigation, and they're allowed access to many records and access onto the premises. So they go do a pretty thorough investigation for maybe a whole morning or something like that.
It's a raid on the file cabinet.
Yeah.
Cool.
So, but there are other ways that someone might get tipped off. Who knows? There's different ways that agencies get tipped off. Sometimes it's just random, and they go, "We're focusing on the agriculture industry. We're focusing on restaurants," and so they may, for a period of time, do more of those types of industries than the others. So anyway, however it starts. Then you can face an investigation, and often those are number one, they're always uncomfortable because someone's in your place of business and they're asking for all this stuff. And, they're looking for a violation. I mean, they are. So the odds of finding something are, pretty good.
Yeah, because they don't want to look dumb.
It's like, I just see this like being like how they do all the DUI checkpoints?
Yeah.
I feel like we got ourselves a convoy.
Yeah.
And they're going in.
They're going in.
But, I mean, do people have file cabinets anymore? I mean, I know they do, but...
Oh, yeah,
but
it's different now.
Yeah, I wanted to ask you this about the demand letter. I'm back to the demand letters because, number one, I know that you're into writing and you're a good writer, and I can see like, okay, we're going to write this letter. Now,
demand.
Do you get writer's block when you're writing a letter? I mean, do you get to be like...
No, I don't. No. I'm so comfortable with it. Yeah.
So now Nancy, back in the day, there was a vendor, and and we have to be nice because they did eventually fix things, so we can't name them on air. But Nancy gets into what she's known for her "you suck" letters, and so this is back in the day. This company screwed us on some computer stuff, and so big one, and so we couldn't get anywhere. So this is back in the day of faxing, and so eventually she got so tired of it. Every day she would fax "you suck," just "you suck," and this is what she did. And eventually this lady from some other country is like, "I want to speak to Nancy Reed. Stop "you suck" letters." And they fixed it.
And they did. They finally fixed it.
A year of "you suck" letters, and finally we won. It was like, this is the craziest thing, but I know. But that's all through fax. Now, demand letters, which I have a few. I've been doing a few of those today, so I was like, this is timely. Ward's coming on, and I'm like, oh. Do you do them by? No, I have a bunch to do. It's like a rants and raves show.
This is personal now. Okay.
Yeah, no, but when you do a demand letter, now that where we are digitally and everything,
I demand.
Do you? I mean, when people get served and someone comes and finds you and tows your car and gives you a letter saying, "Too bad, Charlie," do you have to have them certified and all that stuff? I mean, we don't even have to do that with taxes half the time. All these things have changed. Do you get to do it by email and track it? Yeah,
electronic filing.
Like, how is the demand letters delivered?
Yeah.
There are certain demand letters that do need to be certified by statute. So if you're starting a PAGA claim, you have to spell out the basics of the claim and send it certified mail to the agency. They've just changed that. Now you can send it not via email, but via their portal. But you still have to send certified letter to the employer.
Wow.
But other than that, things have become much less formal, and how you end up sending that letter, I think, to me, depends on who's getting it. If another attorney's getting it, I know it's going to be acted on one way or the other. Now, they may come back and tell me to pound sand, who knows. But there's going to be a reaction one way or the other. If you think that the defendant may be a little slippery, well, then I might send something certified at that point. But quite frankly, now, most of the time I email the stuff.
Wow. And that's why all you attorneys have the thing at the bottom, like, you cannot send this to other people. You can't do this.
Yeah, right.
You can't,
right,
doctors, same thing. All the
do you have
the professionals with you, like, you cannot do anything with this. I'm
and then at the bottom it also says, if you don't want this letter, you can safely unsubscribe.
Well, it doesn't say that at the bottom of my demand letters, but they can't unsubscribe.
Now, okay, so I think this is, you've got such a cool career,
There's so many excuses for not seeing the email.
Not these kinds, because it says on demand, in demand.
No, but I mean, you can say, hey, my computer broke. What? I mean, you can. There's so many.
Oh yeah.
For
Does anybody do that? Like the dog ate my homework.
Yeah, I mean, I understand the mailman comes here and he gives you a letter. You have to sign for it. That's a done deal, man. You're dead in the water. But if you say you emailed it to me, I'm like, I didn't feel like checking my computer for when did you send it? 3 months.
I dropped my phone in the toilet.
Or my computer blew up. Or.
Yeah, I mean, honestly, it's really only a small. Let me restate all that. Most of the time, an email works. Most people do now react to the email, and they know that you got it. I mean, you have the sender's address. You got all that. You could prove it if you need to. But not too long ago, someone did kind of blow me off for a while. So then I sent up a follow-up email with a letter. So the letter got mailed, and it still took a little while, but I did get a response eventually. So you can. I think in the line of my work, an email usually. I mean, really, 99+% of the time, that's enough. People are going to react to it.
Yeah, because it's like you got
if you
stuff
need to
going on and it's
step it up, you can.
Yeah.
Unless you're in a big hurry. In most cases, you're not in a huge hurry. If you're up against statute of limitations, well, that's a different thing. But if you're not in a huge hurry, and so you can send an email, and wait a couple weeks, and if you don't get anything back, you can do something else. So
and for your client, if they have to pay anything, to slow it down. Slow it down. Slow the horse.
Yeah, and you can slow it down. You work with your client on those things. Yeah, sure. I want to continue
this is fascinating. I want to be a demand writer, like a demand letter writer. Yeah, I do. I think it's fun. Well, it's not fun, but it's like it's just this like getting the point across, and if things can stop at that level before everybody gets into crazy land, I think that's awesome. It doesn't always work that way, but I think it's awesome.
No, it doesn't always work.
Yeah, and but like you're saying, like get the attorney first, do things, set it up. It's like brushing your teeth so you don't, have problems later. There's things that we have to do. Put oil in the car.
Well, I mean, you have to take care of business.
You need to maintain it.
Check your car battery.
If you're a business owner with employees and something's happening, you can't. The worst thing to do is ignore it. That is not going to happen.
Yeah.
Because it just really gets the other side angry, and the amount that you're going to lose goes up.
Yeah. Ward, good stuff.
Don't ignore it.
Yeah.
No, don't ignore it.
Don't ignore, never ignore. No. But good stuff. I mean, I had no idea about any of these procedures. I knew about letters, but like now I'm like, I'm into that. Everybody, again, Ward's article is up on blendradioandtv.com. You can go there. You'll see him in our expert department, and also go to his website, bestemploymentattorneysandiego.com. See, that even proves right there he's a good letter writer. Just saying. So check that out. He's also on Twitter at Ward-Heinrichs and Facebook under Ward-Heinrichs. You'll find him there too. And this article will be in the May-June issue of Big Blend Radio and TV magazine, coming out in May. So there you go. Ward, we've got music.
Awesome.
We always like to close off with some music. And since this one is about people having to work to the bones, I figured this as well. They didn't get their money. They didn't get their wages. And so that's the song you're going to hear. I know,
perfect.
Right? This is called To the Bones, and the band is from Southern California, Everett Coast out of L.A. Awesome guys. They've been on our shows over the years, and it's off of their EP, Liftoff. And so here it is, To the Bones. Don't forget, Big Blend Radio airs Monday through Thursday at 4 p.m. Pacific Time, 7 p.m. Eastern Time, and Friday and Sundays at 11 a.m. Pacific Time, 2 p.m. Eastern Time. Thanks so much, Ward. Always a pleasure.
Oh, it was all my pleasure. Thanks for having me.
Thanks, and don't send us one of those letters, dude, okay? Nancy will retaliate with you suck.
You'll get it. You suck.
All right, note to self.
Yeah, I know. I'm just kidding. All right, thanks so much. You take care.
Okay, you too. Thanks a lot.
Bye-bye.
Bye-bye.
Are you a rich man? What do you mean rich? What do you mean? You have a lot of possessions? A lot of money in the bank? What shall make you rich? I don't have that type of richness. My richness is life. My richness is life. Forever.
you can. Poor man, we won't be here very long. We're moving on. And unfortunately, I see it looks like all your laboring is for nothing at all. Now you've done it, you've gone and worn your fingers right down to the bones. Whoa, flesh and muscle broken. You've worn your fingers right down to the bones. Whoa, to the bones. Whoa, 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 to the bones. Whoa, whoa, whoa. Now you're a cigar smoker, a practical joker, a big shot broker, all you ever wanted to be. And unfortunately, I see it looks like all your laboring is for nothing at all. Whoa, now you've done it, you've gone and worn your fingers right down to the bones. Whoa, flesh and muscle broken. You've worn your fingers right down to the bones. Whoa, to the bones. Whoa, 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 to the bones. Whoa, whoa, whoa.
You got an office on Wall Street. I got a cardboard box with a dog seat. You got a brand new van for your timepiece. I got a 10-cent cup, that's a dime piece. You gotta go broke just to want a dime piece. I make broke look cooler than Fonzie, so you can scheme all day with your Ponzi's, and I'ma just stare at your dirty laundry. I mean, Jesus, you got a G6. I make it one day at a time, eating cheese whiz. So middle finger to all of the greedy folks you be with all your boat strength, no ski list.
Whoa, now you've done it, you've gone and worn your fingers right down to the bones. Whoa, flesh and muscle broken. You've worn your fingers right down to the bones. Whoa, to the bones. Whoa, 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 to the bones.